I just can't stomach the fact that I have to live the rest of my life without my mom. My daughter has to live the rest of her life without her grandma.
You're the 34-year-old cowardly head of a goon squad. You have no morals, you have no conscience, and you certainly have no sense of civility.
Judy A. Dixon pleaded guilty to murdering Richard Arenas in June 2013 while the victim was working on a car with his nephew in Mount Pleasant. The gunfire was not intended for Arenas, but he was fatally shot and left lying in his driveway.
He hears several popping sounds. He comes outside to find his uncle lying on the driveway, unresponsive.
Following the shooting, Dixon fled to Alabama, where U.S. Marshals later captured him. He was also linked to an unrelated Providence shooting from 2012, to which he also pleaded guilty. During his sentencing in Providence Superior Court, Mabeline Arenas, Richard Arenas' daughter, attempted to speak but was overcome with emotion, passing her statement to the prosecutor. The courtroom was packed with grieving family and friends. When asked by the judge if he understood the charges, Dixon initially hesitated before quietly admitting to the murder.
Did you hear what Mr. Clement just told me? Mm-hmm. Yes or no?
Yes.
Did you in fact shoot and murder Richard Arenas?
He acknowledged his guilt, stating he didn't expect forgiveness and understood the pain of a broken home. As part of a plea agreement approved by the victim's family, Dixon received a life sentence plus 20 years, with the possibility of parole after serving 20 years. The confrontation outside a food mart in North Providence resulted in the death of Hernan Avila Jr. and injuries to his son, Hernan Avila III. The conflict began when Brandon Pavao and Davin Silva approached Avila III, asking about marijuana. After Avila told them he had none, tensions escalated, and they allegedly threatened to involve others. Concerned for his safety, Avila III called his father for support. Shortly after, Pavao contacted Nicholas Armenti, Devante Neves, and Ernest Keosufan, who arrived at the scene. According to authorities, Keosufan fired shots, injuring Avila III. In an attempt to protect his son, Hernan Avila Jr. stepped in and was fatally wounded. Keosufan fled the state, but was later arrested and extradited.
My father died a hero, and that's all I can. He's a great man, and he's gonna be very missed.
Indicted by a grand jury, Keosufan was denied bail and remained in custody.
So there was considerable discovery.
Prosecutors identified 5 others involved in the case. Pavao, Neves, and Armenti pleaded guilty to conspiracy to commit felony assault, while Silva was arraigned and released on $25,000 bail. Initially, Pavao faced a murder charge for allegedly calling Keosufan to the scene. However, after further investigation, authorities determined Keosufan acted alone, reducing Pavao's charge to conspiracy. In March 2017, Keosufan pleaded guilty and was sentenced to life in prison plus 30 years, with an additional 20 years suspended without parole. In June 2017, Pavao was sentenced to 1 year in prison. The court continued processing the remaining cases as the Avila family mourned their loss. On Halloween night 2016, Matthew Reverdes lost his life in Pawtucket in an incident involving Triera Hudgen and another individual. A jury later found Hudgen guilty of her role in the case. Throughout the trial, Hudgen maintained her innocence, claiming she had been wrongly convicted. During court proceedings, she initially refused to appear and later attempted to leave, but was stopped by bailiffs. When given the chance to speak, she acknowledged the impact on Reverdes' daughter, but continued to deny any wrongdoing.
One day you guys will understand that you have the wrong person, and I hope for the rest of this time while I'm sitting here, you get the answers and the clarification and the gratification to help you move on in life.
At the sentencing, Reverdes' family shared emotional statements, describing him as a devoted father.
His life was stolen from him in a selfish manner and robbed him from being able to raise his daughter.
How can we feel fulfilled again when part of us is missing? You robbed my granddaughter of her friend, her protector, her father. Every Christmas means nothing to her because all she asks Santa for is Daddy.
His mother expressed how difficult life had become for his daughter, who struggled with his absence, especially during the holidays.
I thought that if we sat back and let things take its course, it would eventually work itself out, and it hasn't. So now I have to work it out myself.
The mother of Hudgen spoke.
Since she's been at the ACI, she has
had no less than 36 disciplines.
The judge imposed 2 life sentences, ensuring that Hudgen would remain behind bars for decades before becoming eligible for parole. After the ruling, Attorney General Peter Naranja emphasized the importance of peaceful conflict resolution and expressed hope that the sentencing would bring justice to the Reverdes family. In April 2022, the Rhode Island Supreme Court upheld the conviction that Hudgen's attorney filed following the verdict. Joseph Segrain was convicted for his role in a drive-by shooting in downtown Providence, which resulted in serious injuries to Matthew DePina, who authorities stated was not the intended target. The incident originated from a rival gang dispute in Pawtucket. Before the shooting, Segrain was involved in a courtroom altercation with another group. Later, as DePina was walking to his car, Segrain and others drove by and fired shots. DePina survived but required surgery due to his injuries. Following an investigation, Segrain was arrested and charged with multiple offenses. During his jury trial, he was found guilty on several counts. Throughout the legal proceedings, Segrain caused disruptions in court.
Joseph Siegel, 1083, and she's not my attorney. Let's talk about that. That's what that issue right now.
I'm not going to have you interrupt me.
All right.
You will have your right to
At his sentencing hearing, he refused to enter the courtroom, delaying the process. When he finally appeared, he argued that he had not been given full access to evidence and requested to represent himself, which the judge denied.
You're the 34-year-old cowardly head of a goon squad. You have no morals, you have no conscience, and you certainly have no sense of civility. This defendant is not going to be in a position to reoffend.
Judge Robert Krause sentenced Joseph Segrain to 90 years in prison with 80 years to serve and 35 years non-parolable, plus an additional 9 years for violating probation. Later, Segrain filed a civil lawsuit against the Rhode Island Department of Corrections, alleging excessive force by officers in 2018. In September 2024, the United States Court of Appeals for the First Circuit ruled that his claim against Officer Walter Duffy could proceed to trial, dismissing other claims. Jorge DePina was convicted of second-degree murder for the 2013 death of his daughter, Alida. While the prosecution sought a first-degree murder conviction, which required proof of premeditation, the jury acquitted him of that charge and found him guilty of second-degree murder instead. The case revolved around Alida's passing due to a medical condition caused by injuries. Prosecutors argued that DePina's actions led to her deteriorating condition, while the defense maintained that although he failed to seek medical care, he did not intend to cause harm. The defense pushed for a lesser charge of manslaughter, but the jury ultimately sided with the prosecution.
Certainly we are relieved that this jury did not find George DePina guilty of first-degree murder. We are grateful that they saw through the evidence and determined that under no set of circumstances did George DePina ever intend to kill his daughter. Second-degree murder, while I don't call it a victory, is certainly far better than first and the prospect of life without parole.
Upon hearing the verdict, DePina expressed his frustration in Cape Verdean Creole, addressing his family in court. His relatives in Cape Verde, including Alida's mother and maternal family, were not present at the trial, as they had remained in their home country where the girl was laid to rest. In 2018, DePina was sentenced to life in prison. He later appealed the conviction, but in 2021, the Rhode Island Supreme Court upheld the verdict, affirming his life sentence. DePina remains incarcerated, serving his term. Luis Roman pleaded guilty to 8 charges, including assault with intent to murder, following an incident involving a Providence police officer and his girlfriend. The situation escalated when Roman used an AR-15 style ghost gun to fire rounds at a police cruiser. The officer inside quickly retreated and called for backup, narrowly avoiding harm.
The suspect on the porch fires 9 rounds at the vehicle, 2 striking within centimeters of where his head would be behind the front windshield.
The incident raised serious concerns about illegal firearms, particularly ghost guns, which can be assembled without serial numbers, making them difficult to trace. Authorities emphasized the danger of unregulated firearms, especially in the hands of individuals with prior felony convictions like Roman.
So these guns are out there, they're in the hands of people who shouldn't have them. We're using our tools, both investigative and legal, to go after them. That's what we worry about. Someone heavily armed, to the extent that the police aren't equipped in the first instance of going in to remedy a situation where, in this case, a woman is facing violence. That, to me, is why these guns need to be taken off the street.
Rhode Island Attorney General Peter Naronha highlighted ongoing efforts to remove illegal weapons from the streets and prevent similar incidents. Roman was sentenced to 70 years in prison with 30 years to serve at the Adult Correctional Institutions, ACI. Officials continue to stress the importance of firearm regulations to improve community safety and prevent future threats. A long-standing dispute between LaRon Porter's sister and Tiffany Tallow's sister escalated into a confrontation on Spruce Street in Federal Hill. Earlier that day, the two young women had argued over a boy, leading to Porter's sister bringing him and other family members to Tallow's home. Witnesses testified that when the argument turned physical, Porter intervened, striking Tallow's sister and knocking her to the ground. As Tiffany Tallow rushed to help, Porter fired a shot, fatally injuring her. Following a trial, Porter was convicted of second-degree murder.
It was a significant sentence, much deserved, and LaRon Porter will spend many, if not all of his years in jail.
During sentencing, Judge underscored the gravity of the crime, sentencing him to 2 consecutive life terms plus 35 years, ensuring he would likely spend the rest of his life in prison. His defense attorney described the ruling as a life-ending sentence, acknowledging that Porter may never walk free again. Prosecutors maintained that the sentence was necessary, not only to deliver justice for Tallow's family, but also to send a clear message about the consequences of violent actions. Yusuf Avant, the owner of Crazy Cuts Barbershop in East Providence, lost his life in a tragic incident that remained unsolved for nearly a year. Avant, a respected business owner with family and law enforcement, left behind a son.
The victim has family and close friends in law enforcement. The offense took place in the very neighborhood where I live. So these aren't just constituents, these are my friends and family who live in this area.
Law enforcement initially released a suspect sketch, though it did not closely resemble the person responsible. Over time, investigators gathered evidence linking Thomas Mosley to the case.
We believe that the victim in this case was targeted. It certainly wasn't random. We said that when it happened. We maintain that today.
Authorities later revealed that Mosley and an accomplice, Evan Watson, had planned the attack. Watson drove Mosley to the barber shop, where an altercation occurred before the incident.
As Avant was cutting hair in his owner-operated barbershop on Pawtucket Avenue in our city.
However, officials did not publicly disclose the exact motive or details of their relationship. The case files were later sealed by court order.
The arrest took place on Broad Street in Providence at about 6:41 p.m. and it was subsequent to an arrest warrant obtained by the East Providence Police. We did surveil him, so we picked the time, place, and conditions with which we made the arrest. We felt it was the safest.
In a carefully planned operation, police arrested Mosley in South Providence after securing a warrant.
The synergy between the agencies was instrumental in the arrest.
During his arraignment, he was ordered held without bail at the Adult Correctional Institutions, ACI, in Providence. A review of his criminal history showed prior convictions for felony assault and drug-related offenses, but nothing as severe as this case. Mosley's first trial ended in a mistrial after the jury failed to reach a verdict on the murder charge, though he was convicted of firearm possession and obstruction of justice. In a 2020 retrial, he was convicted of second-degree murder and sentenced to consecutive life terms. His accomplice, Evan Watson, pleaded guilty to second-degree murder, conspiracy, and firearm possession, and was sentenced to 28 years in prison in January 2024. Myron Strambler is charged with murder after Houston police found him covered in blood at a North Houston motel where his wife, Alicia Strambler, was discovered unresponsive in the bathroom. A mother of 3 and an advocate for women, Alicia had been separated from Strambler for 3 years, but had recently reconnected with him.
She went back because she thought this man loved her, and this man, he was a monster.
According to investigators, Strambler admitted to being off his medication and claimed he blacked out during the attack. The couple had a history of domestic violence, with Strambler previously facing charges for assaulting Alicia. Despite her efforts to leave, he refused to let her go.
She did not deserve this. Her kids do not deserve this. He would not leave her alone. She tried and tried and tried. He just wouldn't let her go.
Strambler, a convicted sex offender with nearly 20 years of criminal history, had served prison time and faced multiple arrests in Texas. Alicia's family revealed she had been working on a book about domestic violence, hoping to help others escape abusive situations.
If she even called anybody or contacted, even her father, he didn't want that. He wanted everything to be under his control.
Alicia's sister is trying to seek justice for her.
The justice system has failed Alicia. Let's make it right, and let's make sure he does not ever come out.
In court, the judge increased Strambler's bond to $300,000, while prosecutors pushed for him to be held without bail due to his criminal record. Alicia's family continues to demand justice, urging the court to ensure he remains behind bars. DeAndre Davis was charged with premeditated first-degree murder, robbery, and aggravated assault with a deadly weapon following an incident in Jupiter.
Mr. Davis, good morning. You're charged with first-degree murder with a firearm, robbery, aggravated assault with a deadly weapon.
The situation unfolded when 27-year-old Anthony Jones was attempting to retrieve his lost cell phone, offering $80 in exchange for its return. Davis, who overheard the conversation, allegedly tried to claim the phone for himself. Witnesses stated that he produced 2 firearms and confronted 2 individuals. During the encounter, a shot was fired, resulting in Jones sustaining critical injuries. Following the incident, Davis reportedly expressed regret, stating, "I didn't mean to shoot." Authorities later took him into custody, and he was formally charged. In court, Davis appeared in an orange jumpsuit, facing serious legal consequences. Prosecutors have classified his case under adult jurisdiction, meaning he could face life in prison if convicted. The case moved forward through the judicial process. William Hodges and Brendan Bates appeared in court following their arrest in connection with the passing of 33-year-old Kevin Gonsalves of Milford. Authorities confirmed that the 3 individuals were familiar with one another.
They told them that they were going there to rip off a marijuana dealer for approximately 2 ounces of marijuana. When they got there, Mr. Hodges got out of the vehicle with Mr. Gonsalves. Mr. Bates stayed in the vehicle. Mr. Hodges then shot Mr. Gonsalves several times.
According to investigators, Gonsalves was invited to a vacant home in Blackstone under the impression of participating in robbing a marijuana dealer. However, the situation took a tragic turn. Prosecutors alleged that upon arrival, Hodges and Gonsalves exited the vehicle while Bates remained inside. It was at this point that Gonsalves was harmed. During the proceedings at Uxbridge District Court, prosecutors identified William Hodges as the primary suspect. Meanwhile, Brendan Bates faced related charges, but was not accused of direct involvement in the act. In the courtroom, emotions ran high as Gonsalves' family and friends watched from the front row, visibly shaken.
He was a great kid, that he would give you his back off his shirt off his back.
They described him as a generous and caring person who was always willing to help others.
We love him, and we want to make sure he gets the justice he deserves.
Authorities later recovered what they believed to be the weapon used in the incident, with assistance from the state police dive team in Mendon.
This shooting was apparently out of a dispute, an ongoing dispute between Gonsalves and Hodges.
Officials also suggested that the situation arose from a long-standing personal dispute between Hodges and Gonsalves, though the exact nature of their conflict was not fully disclosed. In a later development, a grand jury dismissed the murder charge against Brendan Bates, though he still faced legal consequences for allegedly misleading investigators and possessing a firearm. Meanwhile, Hodges remained charged in connection with Gonsalves' death. As of the latest updates, details regarding sentencing have not been publicly disclosed. Joseph Voigt, a resident of Bartow, has been charged with allegedly harming both of his parents, resulting in his father's death and leaving his mother critically injured. Authorities reported that Voigt left the scene immediately after the incident.
We got a 911 call from the mother, advised that she had been shot
by her son, and her husband had been shot also.
Law enforcement received a distress call from Voigt's mother, who informed them that both she and her husband had been harmed. Officers arrived at the residence to find 63-year-old Marvin Voigt unresponsive in the driveway, while his wife, though injured, was still conscious inside the home.
So they found the mother sitting up on the couch. She was alive. She had been shot in the head once.
She was quickly taken to the hospital for emergency treatment.
Everything we've heard about this couple is they were really good people. And it's just sad, to see something like this happen.
Following the incident, Voigt fled to Orlando, where authorities later spotted his vehicle on International Drive. He was taken into custody without incident.
It's really sad. It's senseless. Something silly. That he was upset about.
Investigators revealed that the conflict stemmed from a disagreement, with Voigt allegedly reacting after being encouraged to reduce his time spent on video games and focus on finding employment.
You have zero bond on both counts, so you're going to have to seek release from the judge on that case.
After his arrest, Voigt appeared in court where he was denied bond. Authorities described the situation as deeply tragic, emphasizing the profound impact on the surviving family. He is expected to be transferred to Polk County, where he will face charges related to the case. Colby Mendonca, a 26-year-old Army veteran from Pawtucket, lost his life behind a Walgreens on Elmwood Avenue in Providence following a confrontation. Authorities charged 18-year-old Erico Montalvo and 26-year-old Jose Rodriguez in connection with the incident. According to prosecutors, Mendonca had stepped in to help a friend during a dispute when the situation escalated. Montalvo later admitted to the stabbing during police questioning, and a second victim, who survived, identified him as the attacker.
I was able to identify the defendant as the assailant upon him, as well as present during the
Montalvo also faced an additional charge of assault with a dangerous weapon for injuring the second victim. Following his arrest, Montalvo was held without bail, with a bail review hearing scheduled. Meanwhile, Mendonca was laid to rest with full military honors, as his family and friends mourned the loss of a dedicated soldier and friend. Both Montalvo and Rodriguez pleaded not guilty to the charges. In December 2018, a jury acquitted Rodriguez of murder, clearing him of any involvement in Mendonca's death. However, there have been no further updates on Montalvo's trial or legal status. 3 boys, Demetrius Devin Bailey, Jakeem Henry, and Jamarius Benefield, were charged as adults with first-degree murder and 2 counts of armed robbery following a fatal incident at Lakewood Place Apartments in Hillsborough County. According to prosecutors, the boys planned to rob another boy who was sitting in his car. One of them pulled out a gun and aimed it at the victim, leading to a struggle over the weapon. During the altercation, shots were fired and the victim was fatally struck. Authorities identified fingerprints at the crime scene as potential evidence. To confirm their involvement, prosecutors requested a DNA sample from the defendants. The judge approved the request, and DNA collection was conducted. In August 2023, a 4th individual, Michael Shepard, was arrested in connection with the same incident. With Shepard's arrest, all suspects believed to be involved in the case were in custody. As of now, all 4 defendants have pleaded not guilty to the charges and are awaiting trial. If convicted, they could face life in prison. Travis Van Vliet, a 23-year-old college student with no prior arrests, was taken into custody in a Tampa courtroom after violating a judge's instructions during jury selection for a high-profile trial. The judge had explicitly warned jurors not to research the case online, but Van Vliet was overheard telling another juror in the hallway that he had done so. The case involved John Goodman, a Florida millionaire accused of killing a college student in a DUI crash. Goodman, the founder of the Wellington Polo Club, was facing a retrial after previously selling his appliance and air conditioning businesses. When questioned, several other jurors also admitted to looking up the case, prompting the judge to take action. Although reluctant, the judge ordered Van Vliet's arrest. Hillsborough County Sheriff's deputies escorted him from the courtroom as he appeared visibly shaken. Later, he apologized, insisting that he had not intended to violate court orders. Instead of the potential 5.5-month jail sentence he faced for contempt of court, the judge sentenced him to 30 hours of community service, bringing the matter to a close. Tyrell Edwards and Amanda Williams were engaged and living together in Warrensville Heights, Ohio. On October 9th, 2023, around 11:40 p.m., Edwards called 911, stating he had just killed Williams. When police arrived at their Sunset Drive residence, they found Williams, 46, unresponsive with gunshot wounds. She was transported to the hospital but was pronounced dead on arrival. Initially, Edwards was detained for questioning but later released due to a lack of immediate evidence. He claimed self-defense, alleging Williams had attacked him with a knife during an argument. However, investigators continued gathering evidence from forensic reports, witness statements, and Edwards' own emergency call. By early November 2023, after weeks of investigation, a grand jury indicted Edwards, charging him with 2 counts of murder, 2 counts of felonious assault, and 1 count of domestic violence. He later surrendered to authorities. Prosecutors argued that forensic evidence contradicted his claim, pointing out that the trajectory and placement of Williams' gunshot wounds suggested she was not attacking when shot. No conclusive proof showed she had been armed. Testimonies also indicated a history of controlling behavior, suggesting the fatal incident stemmed from ongoing domestic abuse. They also presented messages and call logs to establish a pattern of tension in their relationship.
Review the verdict forms, and they do appear to be accurately or at least completely filled out. Mr. Edwards, you could please stand. The verdict forms in this case, count 1. Verdict reads, we, the jury in this case, being duly impaneled and sworn, do find the defendant, Tyrell Edwards, not guilty of aggravated murder in violation of 2903.01a of the Ohio Revised Code is charged in count 1 of the indictment. It is signed in ink by all 12 jurors, and the specifications are not completed. Count 2, the verdict reads, we, the jury in this case, being duly impaneled and sworn, do find the defendant, Tyrell Edwards, guilty of murder in violation of Revised Code Section 2903.02a of the Ohio Revised Code is charged in count 2 of the indictment. It is signed in ink by all 12 jurors. Pursuant to their directions, the firearm specification. All right. First firearm specification, reads, we, the jury in this case, having found the defendant guilty of murder, further find and specify that the defendant, Tyrell Edwards, did have a firearm on or about his person or under his control while committing the offense of murder is charged in count 2 of the indictment. It is signed in ink by all 12 jurors. Firearm specification 2 reads, we, the jury in this case, having found defendant guilty of murder, further find and specify that the defendant, Tyrell Edwards, did have a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated he possessed the firearm or used it to facilitate the offense of murder. It's charged in count 2 of the indictment. It is filled out in ink by all 12 jurors. Verdict form for count 3, charge of murder. We, the jury in this case, being duly impaneled and sworn, do find the defendant, Tyrell Edwards, guilty of murder in violation of Revised Code Section 2903.02b of the Ohio Revised Code. It's charged in count 3 of the indictment. It is filled out in ink by all 12 jurors. Furthermore, both of the firearm specifications indicate that he did have a firearm on or about his person or under his control. Verdict form for count 4, felonious assault, reads, we, the jury in this case, being duly impaneled and sworn, do find the defendant, Tyrell Edwards, guilty of felonious assault in violation of Section 2903.11a1 of the Revised Code is charged in count 4 of the indictment. It is completed in ink by all 12 jurors or signed in ink by all 12 jurors. Their further findings is that he did have a firearm on or about his person or under his control in both of the specifications, which is also completed in ink. Count 5, charge of felonious assault. We, the jury in this case, being duly impaneled and sworn, do find defendant Tyrell Edwards guilty of felonious assault in violation of Section 2903.11a2 of the Revised Code. Is charged in count 5 of the indictment. It is accurately signed by all 12 jurors in ink, as well as both of the firearm specifications are found that he did have a firearm. Those are signed as well in ink. Finally, count 6, the verdict form reads, we, the jury in this case, being duly impaneled and sworn, do find defendant Terrell Edwards guilty of domestic violence in violation of section 2919.25A. Other revised code is charged in count 6 indictment. It is signed and inked by all 12 jurors. Anything else on behalf of the state of Ohio?
No, Judge, thank you.
Anything else on behalf of the defense?
I just ask that you poll the jury, Your Honor.
All right, so ladies and gentlemen, what I'm going to do is just point to each one of you and ask if those verdicts are your individual verdicts. So, sir, are these verdicts your individual verdicts?
Yes, Your Honor.
Ma'am, are these verdicts your individual verdicts? Ma'am, are these verdicts your individual verdicts? Sir, are these verdicts your individual verdicts?
Yes, Your Honor.
Ma'am, are these verdicts your individual verdicts?
Yes, Your Honor.
Sir, are these verdicts your individual verdicts?
Yes, Your Honor.
And sir, are these verdicts your individual verdicts?
Yes, Your Honor.
Ma'am, are these verdicts your individual verdicts?
Yes, Your Honor.
Ma'am, are these verdicts your individual verdicts?
Yes.
Ma'am, are these verdicts your individual verdicts?
Yes, Your Honor.
Sir, are these verdicts your individual verdicts?
Yes, Your Honor.
And ma'am, are these verdicts your individual verdicts?
Yes, Your Honor.
All right. Thank you very much, ladies and gentlemen. I am going to ask you if you would just retire back in your jury room for a few minutes. I'll be back to join you.
On March 4th, 2024, after deliberations, the jury found Edwards guilty on all counts except aggravated murder at his sentencing hearing on March 11th, 2024.
I just can't stomach the fact that I have to live the rest of my life without my mom. My daughter has to live the rest of her life without her grandma because a coward wanted to take her life. My mom did not deserve this at all. My mother was a family-oriented person. She was my motivator, my best friend. She was the glue to this family. She was my guidance, my everything.
Williams' family members delivered emotional impact statements, speaking about the profound loss and pain caused by her death.
We got what we can get to.
Yeah.
We satisfied, we can go begin to heal.
And thank you to the prosecutor's office. We want to thank Kevin from the bottom of our heart. Without him, we wouldn't have got this far either. And we just also want to thank everyone for the support and coming along with us on this ride.
Her brother called for the maximum sentence.
You know, to say that this is a tragic case is an understatement, to say the very least. The loss to this family, the community, is immeasurable, and there is no amount of time, in terms of years, that is in any way meant to or will ever equate to the loss of Amanda's life, and to do so or to try to do so really is disrespectful to her memory. I do find that counts 2 through 6 merge, and we'll proceed to sentence on count 2. The sentence on count 2 will be a 15-year sentence, or actually it's a life sentence with parole eligibility after serving the full 15 years. That will run consecutive to 2 3-year firearm specifications pursuant to 2914B1G. Additionally, I'm going to serve an additional 3 years of firearm specifications, again pursuant to my discretion under 2914B1G. I'll not impose any fines. I will have him pay 1/2 of the court costs of proceedings. I'll still advise you that you may be subject to PRC upon your release. This will be for a mandatory period of 5 years. If you violate any rules or conditions of PRC, you can go back up for half your time. If the rule violation is a new felony, that time could be run consecutive. Anything else at this point in time, Mr. Filiatro?
No, Judge, thank you. Just to confirm that, then the total sentence is life with parole eligibility after 24 years?
Correct.
Thank you.
Anything else, Mr. Metropolis? Other than to give correct time served?
Yeah. Should we specify what counts each of those 3 are?
I don't know if it's necessary pursuant to the statute. Again, I had the discretion to impose, but it's required that I impose 2 most serious firearm specifications. They're all the same 3-year firearm specifications. If it makes a difference for review in court, I will merge the 2 firearm specifications for each of the felonious assault counts into 1 3-year firearm specification. But that'll run consecutive to the 3-year firearm specification on count 2, the charge of murder, and consecutive to the 3-year firearm specification on count 3, the charge of murder. Anything else, Mr. Metropolis?
No, Your Honor.
All right, and we give credit for time served. shall transfer. Thank you. We'll be at recess.
The judge, considering the evidence and the nature of the crime, sentenced Edwards to life in prison with the possibility of parole after 24 years. His sentence includes 2 mandatory 3-year firearm enhancements and an additional 3-year firearm specification. He must also serve 5 years of post-release supervision if granted parole. The court declined fines but ordered him to pay half of the court costs. Angela "Angie" Hawk, an unlicensed midwife from Riverdale, Nebraska, was assisting Emily and Trevor Noy with the home birth of their daughter in Omaha. The couple, who had previously worked with Hawk for the birth of their first one, chose a home delivery again, hoping to avoid a hospital setting. Labor lasted for 24 hours before complications arose. The girl was in a breech position, making the delivery more difficult. Hawk attempted to reposition the girl, but was unsuccessful. She informed the parents of the risks and gave them the option to transfer to a hospital. However, they decided to continue with the home birth. As labor progressed, concerns grew. Eventually, paramedics were called to assist. The girl was delivered in the ambulance on the way to the hospital, but was unresponsive. Despite medical efforts, the girl passed away 2 days later due to complications from the birth. Authorities launched an investigation into Hawk's role in the delivery. It was discovered that she was not a licensed midwife and did not have the required medical credentials to practice legally in Nebraska. This led to her being charged with negligent child abuse resulting in death, a serious felony under state law.
For starters, Angela Hawk's actions were likely unlawful by her acting as a lay midwife in the home delivery of the Noe's baby. Under Nebraska law, her actions could be seen as the unlawful practice of medicine under the Uniform Credentialing Act and in violation of the Certified Nurse Midwifery Practice Act. Any violation of these acts would be a Class 3 misdemeanor for a first offense. Further, any person engaging in the practice of any profession or business without the appropriate credentials may be restrained by temporary and permanent injunctions. And finally, practice of such profession or operation of such business without a credential after receiving a cease and desist order from the director of the Department of Health and Human Services is a Class 3 felony. Angela Hawk, however, is charged with negligent child abuse resulting in death, a Class 2A felony under Nebraska Revised Stat Section 28-707. Also, the court notes that the parents in this case have certain constitutional rights involving their medical choices for home delivery of their baby, although the court recognizes that the parents' choices are not absolute. This court expresses no opinion on whether home births in general are wise or prudent. This is an issue for the prospective parents and the Nebraska legislature. Further, this case is not a civil case where the plaintiff has alleged that Angela Hawk acted negligently. This is a criminal case where the state has charged Angela Hawk with criminal negligent child abuse resulting in the heartrending death of Vera. There is a vast difference between civil negligence and criminal negligence.
During the trial, prosecutors argued that Hawk had acted irresponsibly by attempting to deliver a high-risk birth without proper certification. They claimed her failure to ensure an earlier hospital transfer contributed to the tragic outcome. The defense countered that the parents had been fully aware of Hawk's unlicensed status and had willingly chosen her services. They emphasized that Hawk had presented the option of a hospital transfer once the breech position was identified, but the parents opted to proceed at home. Additionally, they argued that home births are a personal choice, and many unlicensed midwives assist families without facing legal consequences.
While it is true that Angela Hawk is not a licensed midwife, she does have education, training, and experience in childbirth. Under the facts of this case, the elements which the state must prove by evidence beyond a reasonable doubt in order to convict the defendant, Angela Hawk, of negligent child abuse resulting in death are: 1, that the defendant did cause to permit Vera to be placed in a situation that endangered her safety or physical health, or B, to deprived of necessary care, and 2, that the defendant did so negligently, and 3, that the defendant's conduct in doing so proximately caused the death to Vera, and 4, that the defendant did so on or about June 14th through June 15th, 2019 in Douglas County, Nebraska, and 5, that at said time Vera was a minor child. Angela Hawk first argues that the state has failed to prove beyond a reasonable doubt that she was criminally negligent. Pursuant to Nebraska Revised Stat, Section 28-707 in parens 9, negligently refers to criminal negligence and means that Angela Hawk knew or should have known of the danger involved and acted recklessly with respect to the safety or physical health or necessary care of Vera. Recklessly means disregarding a substantial and unjustifiable risk that Vera's safety or health or necessary care would be endangered in circumstances in which disregarding this risk was a gross deviation from what a reasonable law-abiding person would have done. What makes this case very troubling for the court is to try to separate the rights of the parents to choose a home birth with the criminal charge against Angela Hawk. The Noes knew beforehand what Angela Hawk was all about, and they chose a home birth. In fact, the Noes rehired her after they tried a home delivery with the first child approximately 1.5 years earlier. At no time did Angela Hawk misrepresent herself. Once Vera was determined to be in a breech position, Angela Hawk gave the Noes the option of going to the hospital. It is unclear from this record whether Angela Hawk knew there was a prolapsed cord. Although Angela Hawk did not provide the Noes with all the risks associated with a breech baby, it was the Noes' choice, and they chose to continue with the birth at home. Some 30 minutes or so later, Emily Noes started to deliver Vera. What happened next was tragic, but everyone involved in this case, from the Noes, Angela Hawk, Mickey, the firefighters and paramedics, and the doctors and the nurses at the hospital, acted to the best of their abilities to save Vera. In applying the elements outlined above to the case before the court cannot find that the state has proven beyond a reasonable doubt that Angela Hawk acted criminally, that is, negligently caused or permitted the minor child Vera to be placed in a situation that endangered her safety or physical health or deprived her of necessary care. The court finds Angela Hawk not guilty. Because the court has found that Angela Hawk's actions were not criminally negligent, the court will not address the other issues.
After reviewing the case, the judge determined that the prosecution had not proven criminal negligence beyond a reasonable doubt. He acknowledged that while Hawk was unlicensed, she did have experience in childbirth, and the parents had knowingly hired her. The court found that all involved, including Hawk, the parents, paramedics, and medical staff, had acted with the intention of ensuring the girl's well-being. With this conclusion, Hawk was found not guilty, and all charges were dismissed. The case sparked discussions on home birth safety and midwifery regulations in Nebraska. Some called for stricter oversight of unlicensed birth attendants, while others defended the right of parents to choose home births. Despite the controversy, no new legislation addressing the issue had been enacted. Johnny Gaudreau, a celebrated NHL player, and his brother Matthew were in New Jersey for a special occasion, their sister Katie's wedding. The two brothers, known for their deep bond and shared love for hockey, decided to go on a bike ride the evening before the big event. What was meant to be a quiet moment of reflection turned into an unimaginable tragedy. As they cycled through Oldman's Township, a vehicle struck them from behind. The driver, identified as Sean M. Higgins, later admitted to consuming alcohol before getting behind the wheel. Authorities determined that he had been attempting to pass other vehicles on a narrow road. The impact of the collision was fatal for both Johnny and Matthew.
All right, where were you coming from, sir?
Taco Bell in Pennsville.
Here's your ID. Where were you before Taco Bell?
My house.
Okay, how much have you had to drink today?
I mean, I've been drinking beers, but I haven't had one in like 2 hours.
Okay.
So since the accident, like probably an hour or so.
Okay.
Yeah.
I'm gonna run you through a few tests.
Yeah, that's
All
fine.
right, go ahead and put that cigarette out.
Yeah. And just FYI, I had surgery on my knee on Friday, so
Okay.
I'm gipping around.
All right, we'll get there.
Man.
Kill the lights in front of your car real quick.
Yes, sir.
Step over here for me.
All right.
Just back right up to his car.
Yep.
The lights for me. Yeah. Excuse me.
Yep.
Alright, what I want you to do, just so you're kind of more my height, is lean back into that bumper, kind of sit on it. Lower, right there. Alright. See the tip of my pen?
Yep.
I want you to follow that with your eyes and your eyes only. Don't move your head, okay?
Okay.
The tip, up here.
The top tip or
Yep,
bottom
the top
tip?
tip. See it?
Yep.
You don't wear contacts?
No.
No? No problems with your eyes?
No.
Alright, and you're not injured as a result of the accident?
I'm just freaked out.
Okay. Alright, follow the tip. Don't remember, you can raise either leg, whatever's going to be best for you and your knee.
Yeah.
Alright, so I'm going to demonstrate 1001, 1002, 1003, and so on until I tell you to stop.
Yep.
You understand the directions?
Yep.
You may begin.
1001, 1002, 1003, 1004, 2005, 2006. Good. Sorry, I'm just freaked out. Like, what am I supposed to be doing again?
I'm counting it out loud until I tell you to stop.
Okay. 1001, 1002, 1003, 2004, 2005, 2006, 2007, 2008, 2009, 10,000, 11,000. It's getting hard.
Alright, you said it's been about an hour since your last drink?
About that, yeah.
And how many did you drink?
I mean, since like noon today, like 5 or 6.
6 since noon?
Yeah.
Beer or what was it?
Beer. Just beer. Or light.
Alright, turn around and place your hands behind your back.
Higgins was taken into custody and charged with reckless driving and vehicular manslaughter.
Be killed. You're charged now with 2 counts of second-degree vehicular homicide. Both of those charges are punishable by a maximum 10 years in New Jersey State Prison. Do you understand that those are the charges to bring you before this court and those are the potential penalties that you face?
Yes, Your Honor.
News of the accident sent shockwaves through the hockey world. Johnny, affectionately called Johnny Hockey, had left a lasting impact in the NHL, first with the Calgary Flames and then with the Columbus Blue Jackets. Matthew, a former minor league player, had transitioned into coaching and mentoring young athletes at Gloucester Catholic High School, their alma mater. The Gaudreau brothers were not only admired for their skill on the ice, but also for their dedication to family and the community. Tributes poured in from fans, teammates, and hockey organizations. Meanwhile, legal proceedings against Sean Higgins moved forward.
Thank you, Your Honor. It's alleged on the 29th day of August 2024, Mr. Higgins was driving his vehicle in Oldham's Township when he passed 2 vehicles. When doing so, he struck Mr. Jonathan and Matthew Gaudreau, who were on their bicycles. They succumbed to their injuries on scene. Mr. Higgins then continued a quarter of a mile down the road where his car was stopped. Once he got out of the car, he discarded various items that were evidence in the case. The case was presented to the grand jury back on December 11th, 2024, and the jurors returned an indictment for 2 counts of reckless vehicular homicide, second degree, 2 counts of aggravated manslaughter, first degree, tampering with physical evidence, 4th degree, and leaving the scene of a fatal accident.
A grand jury indicted him on charges of aggravated manslaughter and reckless vehicular homicide.
state's offer at this time, the initial plea offer is in exchange for a plea to both aggravated manslaughter charges. The state will recommend 15 years in New Jersey State Prison. He would have to serve 85% of that pursuant to the No Early Release Act before he would be eligible for parole. He would also have to plead to leaving the scene of a motor vehicle accident for 5, and the state would recommend a 5-year New Jersey prison term for that. The 2 aggravated manslaughter charges would run consecutive to each other, consecutive to the leaving the scene of a fatal motor vehicle accident for an aggregate of 35 years in New Jersey State Prison.
Thank you, Mr. Messing. So at this time, the offer stands 35 years, subject, at least 30 that would be subject to nearer.
Correct, Your Honor. And the state would also recommend a plea to the driving while intoxicated at sentencing.
Very well.
Judge, we said to change the paragraph 1. Paragraph 1 was a 20-year offer from the state, so we need to change that.
So the aggregate is 35 with 30 at nearer.
Correct, Your Honor.
What we're going to do is bring it back for an
The state offered a plea deal that required Higgins to plead guilty to both aggravated manslaughter charges, resulting in a recommended 15-year sentence for each count. Additionally, he would have to plead guilty to leaving the scene of a fatal accident, carrying a 5-year sentence. If accepted, the sentences would run consecutively, totaling 35 years in prison, with 30 years subject to parole restrictions under New Jersey law. However, he pleaded not guilty and rejected the plea deal. The case remains ongoing as the Gaudreau family seeks justice for their beloved sons and brothers. In Waco, Texas, a gathering of motorcycle clubs at Twin Peaks restaurant turned violent, resulting in a deadly clash between the Bandidos and Cossacks motorcycle clubs. The confrontation led to 9 fatalities and multiple injuries, prompting law enforcement to arrest 177 individuals on charges of organized criminal activity. Among those charged was Jake Carrizal, president of the Dallas chapter of the Bandidos. Prosecutors accused him of playing a leadership role in the violence, arguing that it was a planned act of gang-related aggression. As Carrizal's trial progressed, his attorney, Casey Gautreaux, raised serious concerns about the prosecution's handling of evidence. She argued that the McLennan County District Attorney's Office was withholding crucial materials, making it difficult to mount an adequate defense. The issue escalated when a recording surfaced in which Christopher Lindsay, a liaison from the Texas Attorney General's office, stated that prosecutors had deliberately withheld evidence, describing their actions as deceptive. Gautreaux brought the recording to the court's attention, further intensifying her accusations that the prosecution was engaging in misconduct.
I have been tendered audio recordings, at least 2 of them, Your Honor, in the last 2 days. One of them had Miss Amanda Dylann and Detective Jeff Rogers sitting in on an interview with a witness prior to Twin Peaks, Your Honor, that contains information that is exculpatory and that seriously undermines the state's theory of prosecution.
First of all,
Excuse me.
I'm going to object.
May I finish?
No, I'm going to object to the statement right there. These interviews happened after the Twin Peaks shooting. Any assertion of otherwise would just be a flat lie.
Well,
may I finish? I'm sorry. Make the record, Judge.
You may make a record.
Thank you. There are 2 interviews with this particular individual, one prior to Twin Peaks and one after Twin Peaks.
Judge, I'm going to object. That's a misstatement of the facts.
We can play them in open court. But the point, Your Honor, is that this district attorney's office, including Mr. Jarrett and Ms. Dylann and Mr. Reyna, are sitting in a room where witnesses 2 years ago, 2.5 years ago, are making exculpatory statements. And they say that they don't have possession of the recording, but that they had actual knowledge of the contents of the recording. And I'm happy to recite page and verse, Your Honor, of the witnesses and the statements that they've made that frankly should have prevented the state from sponsoring the testimony of all 3 of their quote-unquote experts and would have materially changed my cross-examination of every witness that has testified, save for the first young woman who was a waitress at Twin Peaks. No, she was a cook at Twin Peaks. I mean, I don't know how this isn't Brady And it is certainly willful. And that fine line of saying, well, we didn't have the recording, you were there. They were physically present in the room when those statements were made. I've made written requests for a statement that was just tendered to me today.
Judge, I'm going to object to counsel testifying. If there's a legal objection she'd like to make, then we can do that.
I'll take the stand. These are absolute facts, Your Honor, that have prejudiced Jake Carzal's right to a fair trial.
Judge, the facts, if I could state something real quick, the facts are that there is a co-defendant of Mr. Carzal who voluntarily came and spoke with the district attorney's office with his attorney present. The fact that somebody, a co-defendant, came in and lied to the district attorney's office is not an unusual thing. This information that he lied about then is the same information he's lied about before. No, we didn't sponsor this witness's testimony. We don't intend to call him as a witness. So, to make these assertions is just plain false. The state's ready to proceed at this time.
And Your Honor, I would just direct the court's attention to ex parte David Mark Temple. It is not within the province of the district attorney's authority to determine whether or not a statement is credible or false. Ms. Sigler tried that. If it is contrary to the state's theory of prosecution, and let's face it, this has been a circumstantial case at best, they are duty bound to give that information to the defense. They don't get to just say that it's false.
Again, I'd object to that. The state's theory of this case is not based on a witness statement from a gang member. The state's theory of this case is testimony by your client on his text messages to other gang members, on his actions that are videotaped in Waco, Texas on May 17, 2015, on his actions before, during, and after the crime. The fact that he's continued to be a bandito, the fact that he's ascended to the rank of president after the crime, the evidence is very clear in this case, and it has nothing to do with the statement of a Cossack, one of his co-defendants.
Your Honor, how many times has a state-sponsored testimony that the conflict at Twin Peaks was about a Texas bottom rocker? 3 separate times. And he can say it's a co-defendant, it's a Cossack. This man was a Cossack, and he's saying that there was no conflict over the Texas rocker. What effect does that have on the state's theory all the way up until now? Because we heard so much testimony about that Texas bottom rocker, and they've got evidence of a Cossack saying, and even a non-club member saying that he was present at their patch party, and there was no beef over any Texas bottom rocker. That is wholly inconsistent with the state's theory of prosecution.
Judge, the information that Ms. Gautreaux received this morning is confirmation from confidential informants that are very well connected to a certain organization that this was over a Texas bottom rocker. To say otherwise is just untrue.
So in addition to the allegation under Brady and Maryland, Brady v. Maryland, Kyles v. Whitley, it's 3.09D. The prosecution must turn over evidence that is exculpatory, that is inconsistent with their theory, irrespective of their assessment of the credibility of it, Your Honor. I'd like the court, I'd like to know how long they had it and why they didn't give it to us. I have a stack of subpoenas trying to get this stuff, Judge. And then suddenly it appears at this last hour? You were in the room.
Okay. What relief are you asking the court for?
I would like the court to dismiss the charges for prosecutorial misconduct, for willfully hiding and sitting on information that completely guts their case, Judge. I've outlined all 3 of those men's statements. I mean, I don't see how there's anything fair about this. They were in the room. You were there.
Actually, Ms. Gautreaux, if you want to listen to that tape again, Mr. Ray and I left the room shortly after he started because he's such a liar.
Miss Dylann was there the whole time.
You just said I was.
You started there. Well, you didn't announce your presence or your exit.
Okay.
But you knew.
All right.
I knew a liar was in a room. You're correct about that.
He's lying because it's inconsistent with your theory.
Yes. My theory is your client committed a crime. He text messaged before
I
and
have
after
a theory
the crime.
about his committing crimes.
Okay. Let's address the court. Let's not be arguing between the attorneys. Then the defense's motion to dismiss is denied at this time.
In response, District Attorney Abel Reyna denied any wrongdoing, insisting that all necessary evidence had been shared or was under protective order. He claimed that Lindsay had since apologized for his remarks, offering clarification. Despite these denials, Gautreaux remained firm, arguing that the prosecution's actions undermined the fairness of the trial and violated legal protocols. The dispute over evidence disclosure became a central issue, fueling doubts about the integrity of the case. As tensions grew, the trial concluded with the jury unable to reach a unanimous verdict, resulting in a mistrial. The The outcome added to mounting criticism of how the Twin Peaks cases were handled, with many questioning whether prosecutors had rushed to file charges without fully assessing the evidence. Following the mistrial, most charges against the other defendants were dropped, signaling the collapse of what had initially been one of Texas' largest criminal prosecutions. The controversy surrounding the case highlighted deep flaws in the legal process, leaving lingering doubts about whether justice had truly been served. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.